Thank you, Patty and Suzanne. Thank you, Jessica. We appreciate that. Before we get started this morning, also, we got just a few little housekeeping issues we want to go over with you. If you have any issues during this presentation, your internet burps at home, you get kicked off, don't worry. We are recording this session. We're recording all of our sessions, and we're going to be posting them on YouTube. So if for any reason you get dropped out of this presentation, you'll be able to watch the entire presentation afterward. You'll also have it as a reference that you can go back and look at it again. We also, when we sent you the reminder today for this session, we also sent 3 other links for you. Wanted to review those real quick for you because there's some great information there. We sent you a link to the program, which has not only the bios for all of our speakers, but also a lot of other great information. We also sent you a link to a PDF of handouts for all the presentations. So there's some wonderful material there that our presenters pulled together for you. Then finally, we sent you a PDF link of great caregiver resources that both Age of Central Texas and the Area Agency on Aging pulled together for you. We want to make sure that you have got lots of great information because that is why we have been doing this conference for 19 years. We want to give you the resources, the information, all of the tools that you need to help you in your caregiving journey. One final thing, right down here, there is a chat feature. It looks like one of those bubbles that you see on the comic strips. We want you to talk to us during this presentation. We want to hear your questions as Virginia is presenting this morning, because at the end of our session, we are going to have a facilitated Q&A and we're going to answer your questions. Now, because we are live today and we do have some limited time, we may not get to every single question during the presentation. However, we are going to answer your questions. If we don't get to your question during the presentation, someone from Age of Central Texas or the Area Agency on Aging is going to follow up with you personally and answer your question. Also in the chat box, we have posted a phone number for Michelle Davis over at the Area Agency on Aging. If for any reason you're having technical difficulties during this presentation, we have some retirees from the tech field who are standing by as volunteers this morning who can help talk you through any of your tech issues. So if something goes awry while you're watching today from your side, give Michelle a call and she will connect you up with one of those volunteers and they'll help talk you through whatever the issues are. All right, remember, we want you to ask your questions today because this is an opportunity to get one-on-one with one of the leading attorneys in our area. And it's my pleasure to introduce John Blackard. He is with the Area Agency on Aging and he is going to introduce our speaker this morning. John, take it away.
Good morning, everyone. As Rob mentioned, my name is John, and I'm here to introduce Ms. Virginia Sampson. Virginia Sampson has been an attorney for 34 years. She was a litigation attorney for most of her career and spent a few years as a judge. She recently focused her practice on helping seniors, veterans, and their families as a result of her experience helping her own aging parents. She currently practices elder law in Austin and the Central Texas area. Virginia is accredited with the Veterans Administration to handle claims. She is also admitted to practice law in Texas, Arizona, California, and Pennsylvania. Virginia became involved in elder law and estate planning as a result of helping her parents and their friends navigate the aging process. She understands the challenges and emotional issues we face as we age. She also lost her husband to ALS and understands what it means to face a devastating, life-changing illness. Virginia not only brings her clients many years of legal expertise, but also a deep compassion for them as they navigate these difficult life events. So please join me in welcoming Ms. Virginia Sampson, attorney at law.
Thank you, John. Welcome. Good morning, everyone. I'm so glad you could be here. My heart goes out to you. I get emotional when I talk about caregiving, but you have the toughest job in the world, and I hope a little bit of the information I provide to you this morning can ease some of your burden and stress. And as Rob said, I'm available to answer any questions for anyone about your concerns about any of the issues I'm going to talk to you about this morning. So I'm going to go ahead and share my screen, correct? I have a little PowerPoint presentation for you. All right. We are going to be strictly talking today about how do you navigate health challenges from a legal perspective, right? And that means if somebody's facing a terminal illness or someone is, aging, and the health challenges of that, and what they require you to do to protect yourself and your family in legal terms. So, and remember, this is just an informational presentation. It's not a substitute for any legal advice. Everybody's situation is a little different. And so this is going to give you a basis to be an informed consumer and to make decisions about what you think you need or don't need. But again, it's not a substitute for consulting a professional. All right, so we are going to talk about some myths, right? So we get to this point, I went through this with my parents, we get to the point where they don't really want to talk about what they need, right? You try to bring up, we should have some documents, we should have a will, and somehow this conversation just gets changed or avoided, right? And so we go, okay, well, there's not really a rush right now because, my spouse or my parents are still pretty healthy, we have plenty of time. Well, as we all know, our health for all of us is fragile, but certainly for our parents, our aging parents, and if our spouse has any health issues or any other family member has health issues, we know that can go from not serious to serious literally in the matter of hours. So I'd suggest to you that there is an urgency to planning. One of the reasons that we plan is to reduce the stress for our family and for you as a caregiver, right? If we plan, it's like any planning, life insurance, retirement planning, we get a better result and it costs us less money and we're much less stressed out because we have a plan in place. So I would say it is urgent. And there's a lot of misconceptions about what you can and can't do as a spouse, as an adult child, as a caregiver, in terms of handling the affairs of your loved one who may be not able to handle his or her own affairs, even temporarily. So a lot of us think, because we're taking care of the person, right? We know what their medical issues are. We know what medications they take. We know what their needs are, that we are going to be able to make decisions for them when they can't, or even if they can, they don't always understand what they need, right? I mean, my mom, I used to have an argument. She had to go into community. She had a really serious stroke, and I would go in and say, how is she? Oh, she's fine. Well, how's she fine? Well, she says she's fine. Yeah, my mom is always going to say she's fine, and God bless her. She was not a complainer, but they don't want to admit that they're sick, admit that they need things, so they rely very heavily on us. But that doesn't necessarily mean that you're going to legally be able to make healthcare decisions for them. So I would say that's one of the things we'll talk about a little bit further on, but just know it's not an automatic right. Even if you're a spouse, there is a statute on it, but beyond that, there's a tier of who can make decisions for people who cannot no longer make them for themselves, all right? Financial decisions, that's another piece of it. So we have medical decisions, we have financial decisions. A spouse or an adult child cannot automatically make financial decisions for a person. Now, a spouse, obviously, if you've got joint bank accounts and those kinds of things, you're going to be handling that. But say there's a piece of real property like a house that you maybe need to sell, you maybe need to get a reverse mortgage on, the one spouse is not going to be able to sign on behalf of the other spouse without a particular legal authority to do so. All right, we're going to talk also, so part of our plan today is we're going to talk about what are the basic documents you should have to be able to manage the aging or illness process for your loved one. The second part of the talk is going to be about how do you qualify, are there government benefits out there available to help you pay for long-term care? Because we know for all of us, that's a stressor, right? Long-term care is expensive. Like my parents didn't have the personal financial resources to pay for all of that on their own. And are there government benefits available what are they, and how can we qualify for those? So we'll talk about that in the second part of the presentation. All right, so I touched on this a little bit earlier. I mean, what can I do about this? My spouse or my parents, they just don't want to talk about these issues. Well, I have a couple of suggestions. First of all, let's say, when is the right time to start talking about these issues? And essentially, anyone who's 18 or older should have a set of basic documents, right? Kids go off to college. I mean, they get sick. God forbid they're in a car accident or something, and you don't know who's going to make decisions for them. If their parents are divorced, that becomes even a much more difficult situation. So the time to start is now, right? And why do we want to talk to them? How do we present this to our loved one, right? So, and I'm going to go down to number 4 here. So when you wait to talk to your loved one until they're sick, then they're already feeling very, very vulnerable, right? They already they're already really afraid about losing control over their life. And then you come in, even though we know we're well-intentioned, you come in and you say, okay, now I want you to sign these documents that are going to turn over control to me. I mean, you can guess that it's going to be a hard sell, right? They're going to probably resist at that point in time. Not always, but again, I went through this with my mom. It was quite a battle with her, because I didn't move here to live near me until she was already pretty far along in the dementia process. So if you can talk to them now, that's a good way to do it. And some of the things that I tell clients, right, is that really the point of the documents is to maximize your control over your life as you age or your health declines, right? Because you are going to be able to make decisions regarding who is going to make decisions for you in the event you cannot. That's the point of these documents. You are appointing, for several of them, you are appointing an agent to make a decision for you if you can no longer make them for yourself. So you are getting more control, right? If you don't sign the documents, the alternative is a guardianship proceeding, and that's expensive, time-consuming, stressful, and essentially the judge is going to be making the decision as who is going to handle your affairs when you are no longer capable. So the decision is taken out of your hands at that point in time. So basically, the idea is you're going to have more control over your life if you sign these documents, right? It also is going to reduce your expenses, correct? Because you don't have to have a guardianship proceeding. You don't have to run off to an attorney and say, at the last minute and say, gosh, I need these documents in the next 24 hours. And it's also going to reduce your stress because you, the caregiver, are going to have a plan in place that you are not going to have to face these emergency situations. I mean, the worst thing is if your loved one goes to the hospital, right, and then the doctor or the nurse says to you, well, you can't make healthcare decisions for this person. And you're like, well, what does that mean? So your stress is increased because who can make financial decisions for them if they're sick, even temporarily? Who can make healthcare decisions? If no one's designated, then that's an open question, and that creates stress for you as well as for your loved one. So I would suggest for these reasons, and these are some of the things that you can talk to your loved one about, right? And some ways to talk to them that I just suggested to you that I have found that work with my clients and that did work with my parents a little bit. So, I mean, admittedly, my parents didn't take all of my advice, but I guess that was my payback for not taking theirs when I was a teenager. So, but I would suggest that you think about talking to them gently and quietly and make it about them. And also what I do tell my clients is that, look, these are documents everyone should have. We are not personally directing this at you because you're sick or you're aging. I suggest that everyone over the age of 18 have these. I mean, I have them, I have my kids have them. So it's not something that's directed to someone in their situation. And that's another thing that you can tell them so that they feel like this is just part of life and part of planning in our lives. Like, they would buy life insurance. All right, so now we'll go on to, so that's my little suggestion about how to talk to family members. And of course, you know what works best for your family members. Sometimes it's better if somebody else talks about it. I know a lot of my clients are adult children, and they'll have me talk to their parents about it because, you know, parents oftentimes are more receptive to suggestions or recommendations coming from a neutral third party than they are from their own family members or children. I mean, I've been there. All right, so let's talk about what are the basic legal documents that you should have for your loved one. All right. This is a pretty long list. I typically recommend for sure 5 of them. The others are, you know, discretionary. And of course, there's a whole bunch more depending on what your situation may be that you may want to have. But I'm talking about just basic legal documents that I think everybody should have. So we've got a durable power of attorney. I'll go into these a little bit more. We've got a medical power of attorney. We got a power of attorney for mental health, which is not specifically a Texas sanctioned document, but the behavioral health hospitals like to see that. We have a HIPAA release, an advance directive for mental health, declaration of guardian. Of course, everybody's pretty familiar with the last will and testament, disposition of remains, and a document I think a lot of my clients come to me knowing a little bit about, which is called a DNR, do not resuscitate. So I'll go over all of these in more detail, but this is some of the basic documents. All right. So you've talked to your loved one, you know what documents you need, but then the question is, gosh, you know, my loved one has some dementia, or they have trouble writing. Can they legally sign documents? Okay, and the answer to that is yes, but again, it depends on the situation, right? So the test is for people with dementia or Alzheimer's is the person has to be capable of understanding the nature of the document that he or she is signing, right? They don't have to understand everything about the document, but they do need to understand that if they sign a statutory durable power of attorney, that they are giving authority to the person they've listed there to make financial decisions for them. So that they do need to understand that. Typically, if clients have some dementia, you know, I'll go through a little test with them. I'll ask them, do they know what day it is? Do they know what time it is? Do they know where they are? You know, if they're a little oriented to time and place, you know, do they know who the person is who brought them to me or who's meeting with me, you know, their wife, their daughter, their husband, whatever it may be. Then I feel like they're oriented a bit to time and space, and we can get into a little bit more detail about whether they're going to understand the document and do they want to execute these documents, right? So unlike in criminal court, I think we've all seen enough TV where, you know, is somebody incompetent to stand trial? So there's basically a standard in criminal court. There's no universal standard here. Elder law is relatively new, and so we don't have a universal standard. Really, it's up to the individual attorney to assess the mental capacity of the signer on a case-by-case basis. So everybody may be a little bit different, but that is our ethical obligation, is that we have to believe the person is capable of understanding the nature of the document he or she is signing. We're not ethically allowed to have a person sign a document who doesn't understand the nature of the document, the consequences of signing it. And then my last part, again, is people who have been diagnosed with dementia, some kind of mental impairment, may be capable of signing a document. Of course, someone can challenge it later on. I guess they could always challenge it on the basis that they were not competent. You know, if somebody has trouble physically signing a document, that's not typically an issue because I notarize all these documents for my clients. So if the person has a valid ID, then they can, if they sign an X or something or do some kind of a scribble, as long as a notary has witnessed it, then that should be a good signature. All right, so let's talk now about the individual documents. I'll give you a little bit more information about them. I mean, you know, we can't go into all the details. I'll just give you a brief overview of what each of these documents does. So we have a statutory durable power of attorney. So this is where a person designates an agent to make financial decisions for them or to handle their financial affairs. This can be, Texas has really broadened the scope of these documents. They can allow a person to do everything or very little. And again, those are choices that the person executing the document will make. And so you usually authorize them to do all of it, but there's things like gift giving and a whole bunch of things that can go into this. It can get a little complicated, or again, it can be very simple. And a lot of that's going to depend on the type of assets the person has, what the specific needs are at the time, to how extensive you want to make this, what's their history with their financial transactions, what those kinds of things. The durable power of attorney, the person signing it makes a choice. They want it effective immediately, or they want it effective when they become disabled, mentally incapable of handling their own affairs. So for older clients, I typically recommend it be effective immediately. For younger clients, typically I will say when they can become incapacitated, and that's based on that. How you become incapacitated is set forth in the document itself, and typically it's based on a doctor's report indicating the person is not capable of handling their financial affairs. And remember, for a younger person, that can even be temporarily, or maybe they're going surgery, maybe they're going for some medical treatment, and it doesn't have to be long term. And in those cases, you can put on there a date on which you want this financial power of attorney to end. So this becomes a big issue if your loved one is going to have to go live in some type of a community, independent living, assisted living, or skilled nursing, right? Typically, the community wants you to present them with a valid statutory durable power of attorney. And one of the reasons for that is because they want to know who is going to be financially responsible for this person while they're in the community. That doesn't mean you're responsible for paying the bill. It just means that you are responsible for making financial decisions for this person, right? So say, a contract has to be signed as to how much they're going to pay monthly or annually. An agreement has to be signed as to the increase in the fee. Someone has to sign for this person if they're incapacitated in that sense. So typically the community will want this. Every community is a little different, but it can't, if you want to place your loved one in a community and you don't have this and they insist on it, that can present a stressor for you. All right, the other one is a medical power of attorney. So this authorizes a person, a designated agent, to make financial decisions for the senior. Now remember, when I say designated agents for the statutory durable power of attorney or the medical power of attorney, that's persons that the person executing the document has selected, right? They decided they want this person to make financial decisions for them, this person to make healthcare decisions for them. Now, I always recommend that you have one agent and then one or two successor agents, just in the event the first agent may be out of the country, may be unavailable, something may happen to that person, and then you don't have to worry about executing a new document, because of course if you do this and then somehow you become incompetent and your only agent is gone, then you're not executing a new document, right? You're not mentally capable of doing that. This is just my personal preference as an attorney, I don't recommend people have co-agents. So you can have two people be an agent. The problem with that is I think it just sets up a situation for a conflict later on, right? Whether it's financial decisions or healthcare decisions, we know everyone deals with stress a little bit differently. And even if people get along great when the document is executed, they may not by the time the document is activated. So like we did this for my parents. My brother was the financial power of attorney. I was the healthcare power of attorney. And of course we talked to each other. And we didn't fortunately have any conflicts, but if there had been, my brother would have made the financial decision. I would have made the healthcare decision. And in my personal opinion, that's just a better situation. But again, you need to do what's best for your family, and whatever the professional you consult would recommend to you. I would suggest that you follow their advice. So the medical power of attorney is a little bit different than the financial power of attorney. Remember, the financial power of attorney, the person executing the document gets to select, is it effective immediately upon the date it's signed, or is it effective when the person becomes incapacitated? A medical power of attorney only becomes effective when the individual can no longer make his or her own healthcare decisions. Again, it's usually required by a community. When the senior is going to go live in a community, You know, it's the same situation. They want to know who they call if a medical decision has to be made. You can order medical services for a loved one with this. And lots of times, you know, medical power of attorney, you may have signed it at doctor's offices, but like if your loved one goes into the hospital, this is a document you would take and present to the nurse or whoever they want you to show it to there, so that if your loved one's in the hospital, you can make healthcare decisions for him or her. So that's one of the documents you would want to take to the hospital. The mental health power of attorney, I'm going to table that for right now because I think I'm talking probably a little bit too long. You can ask me about that. It's not a sanctioned Texas Texas document, but the Behavioral Health Institutes, Oceans, and Georgetown do advocate that people have that. All right, the HIPAA release. So we know that the medical information is protected, right? So this authorizes people that the loved one lists in the document to speak with or share medical information with that agent. Again, doctors, if you go to a doctor, you've probably signed this in their office, but it's usually limited to just that doctor. If you do it, if they go in the hospital, then again, you're going to want to have this take this document with you to the hospital so that they'll discuss the medical information with you. Now, if you're in the room and the doctor comes in, that's considered implied consent. But if you want to call the doctor or you want to talk to somebody, they would want to see this. It also allows you to speak to health insurance companies, and we know that can be a big issue. Health insurance companies will not speak to you without a HIPAA release. So if there's a problem with payment of claims or anything like that, you're going to need to have this document. Advance Directive is also, it's your end-of-life wishes in non-emergency situations, right? So you have a couple of situations, you have a life-changing event, perhaps like my mom did, you have a stroke, or you have a terminal illness, and do you want to be kept comfortable and allowed to die peacefully, or do you want all aggressive treatment? And again, this is only going to kick in if you can't make your decisions at the time. Right? This takes some stress off of your agent who's appointed for your medical power of attorney because they know what your wishes are in the chance that one of these events happens to you. This is the same thing. This is an advance directive for mental health issues. Is again, do you want treatment or not treatment? This one is a little bit more complicated, and usually I recommend that it be completed with the assistance of whoever the loved one's treating physician or other healthcare professional is. The declaration of guardian is basically, we talked about when you would have to have a guardian appointed. If nobody signs these documents, the person becomes incompetent, decisions need to be made for them, then they have to go to court and a guardian has to be appointed. There's two types of guardians. One is a guardian over the person who makes the decisions for where the person will live, medical decisions for them. The other is the guardian over the state, which makes financial decisions for them. That can be the same person, it could be two different people. This is a document that the person who executes it signs and says, look, if I have to go to court, these are the people that I want to be my guardian. And it expedites the process, hopefully saves some money and time and some stress, right? We don't have family members fighting over who's going to be the guardian. It's already been decided. Unless somebody has a criminal background or some red flag in their background, the judge is pretty much going to go along with whoever you have designated in your declaration of guardian. We have a do not resuscitate form. You've heard about this. This is for emergency situations only, right? Typically when 911 is called. That's why it's different than the advance directive. Advance directive is non-emergency. This is emergency situations. I don't typically help clients with this because it does require the signature of your treating physician, or the person's treating physician, to say you're competent, or he or she is competent to execute this. And it only applies to these 5 situations. And all of that is contained in the document itself. Disposition of remains, I don't typically do these, but if the person is concerned about people not agreeing with how they want to, be disposed of after death, whether they want cremation, burial, the person can designate an agent to make those decisions for them. We know what a last will and testament is, right? So it's you express your wishes about how you want your assets distributed upon your death. Typically, a probate proceeding is opened in the county where the person resided or the death occurred. And again, it assures the loved one that their assets will pass as they desire. right? This document needs to be notarized. You need 2 witnesses. And there are ways of avoiding probate, right? And this may be one reason you want to consult a professional. Probate can be, and Texas is not too onerous, you know, but you do have to go in. Somebody has to be executor, has to hire an attorney, go in, file the will with the court, and go through an administrative process. The point of probate is to gather up all the assets, pay any creditors, and then distribute the remaining assets to the people designated in the will, the beneficiaries. I'm sorry, I feel like I'm rushing, but I just noticed I want to leave some time for questions. So we're talking about long-term care, right? And this is, the cost of care in Travis County has varied a lot lately, but let's say it's roughly about $5,000 per month. And again, that's going to depend on whether you're independent living, assisted living, or skilled nursing. So it is expensive. And how do you pay for that, right? You can use your personal assets, right? Or you can do long-term care insurance, but typically by the time you need to go into a community, you're not eligible for long-term care insurance, or the premium's going to be way too expensive. We do have Veterans Administration aid and attendance benefits. There is Medicaid, and there are reverse mortgages as ways to pay for long-term care. So we know on personal assets, I mean, it's difficult to save that kind of money. Most people, including my parents, don't have enough assets to cover the cost of long-term care for the remainder of their lives. And as you as caregivers know, if that's an issue, it was for my parents. My dad ended up taking care of my mom much longer than he probably should have, which I feel terrible about. But so a little planning here you may know what assets are available so that you don't get in that situation where the caregiver puts too much of a strain on themselves because they don't have the funds to put their loved one in a community. There's other reasons not to put your loved one in a community, I understand, but we're just talking financial here right now. All right, long-term care insurance, really, you know, it's something that younger people may want to consider because all the programs have changed right now, but typically it does give you some amount of money to pay for assisted living or skilled nursing, right? It's daily benefits for however many days you're in there. All the policies are different, but it does help cover the cost. Some of them cover all of it. Some of them cover part of it, give you a certain daily amount, but it's something that probably you should at least investigate, I would suggest. We have Veterans Aid and Attendance benefits. So it's the government, so there's several pieces to the eligibility, but the first piece is the veteran has to have been in active military service for 90 days at least, just with 1 day during a period of declared war. And the government has set out periods of time in which they consider wartime. So if the veteran served 90 days of active duty, just 1 day period during a period of these dates set out by the government, then they are eligible at least for the military piece of this, right? So I still have some World War II veterans, we have Korea, we have Vietnam, and those dates are set out by the government. The veteran must not have been dishonorably discharged. And how do you find out about this? Whether they're eligible? Everybody who's discharged should have a DD-214. If you don't have that, you can go to archives.gov and you can request one for free from the government. The veteran has to be 65 years of age or older or permanently disabled. And sadly, they changed the requirements in October of 2018. There is a look-back period now. Your medical expenses must exceed your income. And so typically this kicks in when someone goes into assisted living or even independent living, because if it's documented properly, then the entire cost of the community can be considered a medical expense. They have an asset limit. Now you can spend down on that. Certain assets are exempt. For example, your home is exempt. And of course, you have to have a medical need. You need to require assistance with a daily living task. And again, the government defines that. What is a daily living task? All right, so what the VA aid and attendance does is it gives you a certain number of, oh, I'm sorry, I skipped a slide, here we are. It gives you a certain number of money each month that goes directly to the veteran, and that money is in their checking account, and then they can use it as they want to, right? And so a married veteran can get about $2,200 a month. A single veteran, $1,912. Surviving spouses can get $1,230 a month. And to be a surviving spouse, you must have lived with and been married to the veteran at the time of his or her death. If you are divorced from that veteran, you are not eligible. Now, unless you remarried another veteran, but if you divorce them, typically you're not eligible. There is a certain period of time where the government has made an exception about that. So that's why you should probably consult an accredited VA attorney to find out if you are eligible, if you're a surviving spouse. I was able to get this benefit from my mom, and it did help a lot because my dad had served in World War II. And then if you are a veteran who's healthy but your spouse is ill, there's a benefit for that, for you too on that. The benefits do go up about 3% a year. They track Social Security. The asset limit does go up slightly each year. It increases. And this is tax-free. Once you qualify, you really don't have to do anything else to re-qualify. I mean, if your situation changes and somehow you would become ineligible, you need to notify the Veterans Administration. But if you qualify and everything remains pretty much the same, then you have this benefit for the remainder of your life. So we're going to talk about Medicaid. Medicaid applies only to skilled nursing communities. It's different than Medicare. This is a state program. There's a bunch of programs for Medicaid. I'm just going to talk about the one that pays for skilled nursing care. It covers almost the entire cost of the community. It depends, again, on what your individual situation is, but you do have to be in a licensed skilled nursing community. Those are listed on Medicare.gov. They've also got some ratings there. Some assisted living do have designated Medicaid beds. You know, there's usually a waiting list, but that's something that's possible. The asset limits on this are worse. You can only have about $2,000 in assets, but those assets can be restructured. You can have that. This is for an individual, $21.99 a monthly income, but again, that can be dealt with. There's a 5-year look back period. So in other words, people can't come. It's the same with the veterans. People can't give all their assets away to their kids and then say, okay, now I'm eligible. The government is going to, for veterans benefits, going to look back 3 years and ask what you've transferred away. And if you have transferred them away without receiving fair market value for the asset, then you are going to be counted as still having that asset. The same goes with Medicaid. If you've given assets away in the past 5 years for which you did not receive fair market value, those assets will still be countable for you. Again, assets are exempt, and there is a way you can restructure, you can spend down money. So again, you may want to, if this is something you're serious about, I would recommend you consult a professional, an attorney, about how to become eligible for Medicaid. Because if you start doing it yourself, you can mess it up. One good thing is there is an exemption as between spouses. So up to a certain dollar, you can typically transfer, like my mom had to go into skilled nursing with the stroke. You can transfer all the assets. We could transfer all the assets to my dad. Not that there were a lot, but we transferred assets to my dad and she became eligible for Medicaid. That was because the state does not want to impoverish the spouse that is not living in the community, right? They need assets to live. But that is only available as between spouses. So you can see why it gets a little bit complicated, and it's a good idea to maybe talk to a professional about it if you have any assets, if you don't automatically meet the criteria. All right, I'm going to talk a little bit about, taking care of you, the caregiver, right? You are the most important asset, and you have to be able to take care of yourself to take care of your loved one. So show yourself the care and concern that you show your loved one. You should show that to yourself because you are important too. And you need to be cared for and valued and nurtured also. So if I can open to questions, I can answer elder law questions. I do estate plan, I do probate, anything you want on VA questions, Medicaid questions, I'm here to help you.
Hey there. Excellent presentation, Ms. Sampson. We do have a couple questions here. The first one is from Jaceel Bradford. She asks, I don't want to control or make decisions concerning my elder mother's affairs. Rather, I want to be able to receive and interpret info that she may not be able to manage or understand. What documentation do I need?
Well, there is a supported caregiver. You can support decision making. And lots of times people will do that if they have children or relatives that might be just have Down syndrome or something like that. But, you know, you don't, just because you're appointed as the agent doesn't mean you have to exercise that power. It just gives you the authority to exercise that power if you need it. So I would suggest that you do the durable power of attorney, but you don't necessarily have to exercise that power, right? You talk to your mom about it, you come to a joint decision, and then it would your power to kick in would be as if she were no longer able to help make the decisions.
Thank you. Next question we have is from Mr. Gary Gilbert. Is that if I have all other documents, then why would I need a declaration of guardian?
No, you don't necessarily need that. If you have the other documents, that's fine. When people come to see me, I typically include that because I'm doing a whole set of documents, but I don't think you necessarily have to have that one. That's probably the least important one because honestly, most people don't need guardians. So I would say don't worry about it.
John, I'm going to hop in here real quick. I want to introduce Alice Navarro and Yvette McVie, who are also with the Area Agency on Aging. They are going to join us on these Q&As because they are also experts in legal issues, especially with caregiving. So I wanted to introduce them and bring them into this conversation as well to help answer some of these questions. So John, I'm going to turn it back over to you to continue with the questions. For all of our participants, you're asking fabulous questions. Remember, this is your opportunity to get all those questions answered, so be sure and ask them.
All right. And so next question is from Rosanna. So how much does it cost to probate a will in Texas?
It depends on the type of assets. Obviously, the fewer assets you have, the less expensive it is. But I'd say generally probably a couple $1,000 because you have to pay your filing fees, you have to serve, and then of course you have to go through the probate process. If you only have a piece of home, you can do a munum and a title. That's much simpler. Or you can do a small estate affidavit. They're less expensive because they're much simpler, faster processes.
Thank you. All right. And then next question would be, is actually going to be from Mr. Rob. It says, my mom assigned power of attorney to my sister several years ago, but my sister is out of the picture now, and I am the primary caregiver now. But I don't have power of attorney and can't execute important things for my mom. Is it possible to change a power of attorney?
Yes. The best thing I would suggest if your mom is competent is to just have her do a new power of attorney. Because the laws have changed and it wouldn't hurt to have a more current one. If she's not capable of doing that, that's a different situation. But if she can, I would just say execute a new one. In all the documents, in all the powers of attorney, there's language that says, I hereby revoke all prior powers of attorney. Oh, I lost you.
Sorry about that. Next question is from Ms. Linda Braswell. It says, should everyone consider naming a guardian?
I think if you've got if you're going to do documents, I think it's a good idea to do the declaration of guardian. If you've, like we said before, if you've already got the other documents, I wouldn't worry about it. I mean, if you have a real issue, like I have a client who had some kids, a lot of kids, some of whom did not agree with her philosophically. So she felt it was important to designate who would be her guardian so that someone that didn't agree with her in terms of healthcare decisions would not end up being her guardian. And that's something to consider. We love all our kids, but you know, some are better with money and some are better with other things. And that's one of the reasons you do these documents, is that you can pick the person or your child or your loved one or your cousin, whoever you think would handle it best and aligns best with what you would want.
Perfect. All right, thank you. Next question is going to be from Jaceel Bradford. So, is it desirable or practical that persons with medical powers of attorney also have someone responsible for HIPAA release and or advance directives?
I'm not sure if you're asking me if they necessarily have to be the same person. An advance directive.
I believe that's the question.
Okay. An advance directive doesn't designate a person unless you can designate a person there that would be different than your power of attorney. I think it's just a personal preference. A HIPAA release does not require you to name one person. You can name a bunch of people in there. So it just may complicate things. But again, that's your personal preference. Depends, I guess, on whether they're physically present and where you are and, you know, what the logistics of that would be. I don't think you necessarily have to have them all be the same person. There's no legal requirement.
All right, thank you. Next one is from Miss Sandra. It says, my husband was in the Air Force Reserves for 23 years. He was sent to Turkey during Desert Storm. Does he qualify as a vet?
That's being a reservist is a little bit difficult. It depends on whether they were served in active duty for the 90 days during one day of declared war. So he may be. Really, the discharge paper would show that. It will show periods of active duty, right? So a DD-214, and we didn't always have those for World War II, but a DD-214 is a discharge from active duty. And on the DD-214, it will have the date they entered active duty and the date they were separated from active duty. And so if that period of time meets the requirements, he would be eligible.
Great, thank you. We got another question from Rosanna. What assets are exempt when determining eligibility for veterans aid and attendance, besides the personal residence?
A car, obviously your personal belongings, that's pretty much about it. Anything else is pretty much considered an asset, and any income, even if it's IRA income, pensions, retirements, dividends are all considered income.
Great. Another question from Jaceel Bradford. To what extent does it matter if an adult child and or grandchildren outside of the state, should grandchildren ever be involved in these decisions?
Again, I think that's personal preference. I just had a client who appointed his grandson as his, to take care of his financial affairs. So I think it's just who's responsible, who's in alignment with your values. You know, obviously if it's a grandchild, you might want to ask them, did they think that's too much of a burden? You know, we called up the grandson and talked to him about it. So again, I think it depends on your family dynamics.
Okay. Very good, thank you. Next question is from Nancy Bell. So will Medicaid provide money to pay the nursing home monthly fee when a single person doesn't have enough income to cover the amount? i.e. TRS pension, Social Security, and no savings doesn't cover the monthly nursing home payment due.
Yeah, that sounds like, yes, it sounds like that person would be eligible. With Medicaid, the money is paid directly to the community, right? And so when you go through the Medicaid application process, it will determine how much that person needs to contribute and how much the state, but typically the entire cost would be covered.
Very good, thank you for that. Next question is going to be from Denise Snyder. She's asking about avoiding probate. Can you touch a little on this?
Sure, so there's some simple things in Texas. If you have a personal residence, any real property, you can do a transfer on death deed, you can do a ladybird deed, and what happens with those is immediately upon the death of the person who owned the property, it will pass to whoever you've designated in that deed. Right, so there's no probate necessary for that. This is important in Medicaid. If the person who executes the deed has received Medicaid, the state can come in and put a lien on the residence and ask to be reimbursed for what they've paid in benefits to that person. But if you have a transfer on death deed or a ladybird deed, then at that death, that person no longer owns that home and they can't assert a lien. But there's other things you can do. There's some type of trust, but there's also beneficiary designations. You know, they're very simple things. Designating a beneficiary on a bank account, designating a beneficiary on any investment account, of course on life insurance, and doing these transfer on death or ladybird deeds.
Thank you. Next question is going to be from Leif. So are veterans benefits that you discussed earlier only available for long-term care needs?
The benefit I'm talking about, the aid and attendance benefit, yes, I would say, because it has to be, when you submit your application, you have to put down as medical expenses things that will be continuing and regular for at least 12 months, right? There are other veterans benefits for shorter periods of time, but this is called a special monthly pension benefit or aid and attendance, and it is typically for longer term.
Okay. Next question is from Bob Waller. With fewer assets, you may be able to get letters testamentary instead of the full probate process, which is quicker and less expensive.
Well, the full probate process, the only things I'm aware of are like a muniment, a title if all you own is a house and there are no other debts, or a small estate affidavit, $75,000 or less in the estate. Otherwise, you're going to do pretty much a full probate, which again is filing the will, gathering up the assets, notifying creditors, paying any debts, and then distributing.
Next question is from Karen Choate. What about transfer on death documents regarding real estate and bank accounts? Does having them lower the cost of probate?
Yes, because those assets will not have to pass through probate. Even if they're dealt with in the will, if they have been disposed of prior to death, in terms of designating a beneficiary in a bank account or beneficiaries on a transfer on death, those will not have to pass through probate.
Very good. All right, next question here will be from, was Vietnam a declared war?
Yes, that's a great question. So if you go to the veterans website, they list the dates on there. It's a little bit different for Vietnam because it was not a declared warfare period of time. So the government has set out a period of time where you had to be boots on the ground in Vietnam, and then a second period of time where you just had to be active duty for 1 day during the second period. So it depends on when you served. If you served during this earlier period, you had to actually be in Vietnam. If you served during the second period, you could be anywhere as long as you were serving in active military at the time. And that's listed on the VA website. So if you go to VA website, you can find these dates on there. And I'm happy to provide them to you too.
Okay, thank you. Next question is going to be from Jay Capistran. With Medicaid long-term care, it is said to be best to have a transfer on death deed to protect assets. Is this correct?
Yes, that will protect the house. And so again, when the person is receiving Medicaid and they die, the state comes in and can ask that, try to attach a lien to the house and say, we want to be paid all the benefits that we gave to this person. If they no longer own the house on death, then the state can't do that. They can't seek reimbursement.
We have another question from Loretta Tubbs. If you have a ladybird deed and the only other assets are the contents of the house, should you still probate the will, and how much will it cost?
I would, if you came to me, I would say, no, don't probate the will. I mean, can your family members agree to how they're going to distribute the personal assets in the house? I don't think you need to do it for that. Unless you have like an art collection or something of incredible value, I would say no.
Okay. All right.
Virginia, I want to pop in here and ask a question about Ladybird Deed. For some folks that have a second mortgage on the house that they have taken out to help pay for the long-term care costs, when the person passes, then how does all of that come into play?
Well, the person will own the house, but there'll still be, the mortgage is still on there. So they'll either have to sell the house to pay off the mortgage, or they're going to have to, if they want to keep the house, then they're going to have to apply for their own financing or assume that mortgage. So you transfer ownership of the house, but the mortgage does not go away. It's still, the money is still owed.
And so then the Ladybird Deed allows just a little bit more time to figure that out for the family. Is that correct?
It avoids probate, and it can avoid a lien from the state for Medicaid. Right, but it does avoid probate. Yes, and it depends on who the mortgage holder is. A lot of them will let you work with, they'll give you some time to sort all of that out. yes. It's typically it's not immediately due. But again, that depends on the company. But they do give you typically time to sell it or refinance it if somebody wants to keep it or anything like that. If it's a reverse mortgage, that's different. Reverse mortgage is totally different. A reverse mortgage, my understanding is, has to be paid upon the death of the person, right? But I don't do reverse mortgages, but just know that a reverse mortgage is very different than a traditional mortgage in terms of when it has to be repaid and how.
And if you don't mind, just one more time, review for us what a ladybird deed is, because a lot of people have never heard of this and it's very unique for Texas. So if you don't mind, just review what it is and how someone would go about getting that for mom and dad.
Okay, so there are a few states that allow ladybird deeds. So a ladybird deed is a deed that you do during your lifetime. And what it does is that it says upon your death, ownership of the house immediately transfers to the individuals that you have designated in that deed, right? You can designate more than one person, you can designate equal shares, but it does not change your ownership during your lifetime. You still have all the rights of ownership. You can lease it, you can sell it, you can mortgage it. It basically only becomes effective upon your death. And in 2016, we came out with transfer on death deeds that essentially do the same thing. There's reasons to use one or the other, but just know that it doesn't affect anything while you are alive. It only affects things upon your death, and it transfers to the people you have specifically identified it in the ladybird deed, who you identified as people to own the property upon your death.
Terrific. Thank you so much for that information. We're going to take just a tiny little short break because I've got a quick video I want to show you from one of our sponsors, the Texas Senior Living Locators. We're going to come back. We've got a few more questions that we're going to answer. And I also want to bring Alice and Yvette back into this conversation when we come back, because I want to talk about resources that are available to caregivers through the Area Agency on Aging. So I'm going to show you this video very quickly, and we'll be back in just a quick second.
Hello, my name is Michael Gill, and I own Texas Senior Living Locators. I have a free consulting service helping families of seniors find assisted living, independent living, and memory care. It's a free service to you because I'm paid a commission by wherever they end up going. Unlike all the online companies, I am a service that's boots on the ground, meaning I have visited every place in town, whether it's independent living, assisted living, memory care, or small personal care homes. I'm objective, and my only goal is to help your parent find the best place for themselves. The criteria we use is to find the place that's closest to family so that family can visit as often as possible, where it's an appropriate price point, because of course not everybody can afford everything that there is in senior living, and where they get the best care possible. Now, people often ask me, why do I have to move from the house? You don't have to move from the house, and it's an intensely personal decision when the time comes to move your parent. I have 3 rules, however, when it is absolutely necessary that you move. The first rule is, if somebody is a danger to themselves at home, then they must move. This could mean that somebody is taking their medications inappropriately. For example, I've gotten called many times for somebody who's in a nursing home or in the hospital because they have overdosed on their medications by taking them 5 times in a row because they forgot they'd already taken them. In this case, somebody ends up in the hospital. So that's one reason why somebody may be unsafe at home. Another reason may be that they're wandering outside, or they're driving inappropriately, or they're leaving the stove on. You can imagine all the different possibilities. The second reason that you need to move from a house to an assisted living or nursing home type of scenario is when somebody would be healthier if they were away from home. Most of the time what this means is that they're doing a lot of self-neglect. For example, they're not taking their medications, or they're not eating appropriately, or they're a big fall risk. Sometimes it's just better to be in an assisted living or memory care. The third reason that you have to move is when there are caregiver issues. By this I mean, for example, an 85-year-old woman who's taking care of her 90-year-old husband, and now she's aging out of the ability to be able to give him all the care he needs. Or where the children can't give enough help to their parents because the parents are falling during the daylight, during work hours, or when you can no longer afford paying for enough care to come into the house and just makes more sense to move someplace else. At any rate, my name is Michael Gill. I own Texas Senior Living Locators. If you call me, I can help you find the best place for your parent or loved one, and we can do an efficient search together. Usually I'll put people in my car and we'll go visit places together. In times of the coronavirus, of course, that's not always possible. So what we end up doing is a lot of Zoom calls and Zoom meetings. So we're doing virtual tours. But we can get you a good idea of what's going on even during pandemic times. Again, Michael Gill, Texas Senior Living Locators is my company, TexasSeniorLivingLocators.com. And if you want my phone number, it's 512-630-7133.
You know, Michael brings up some great points there about long-term care, and again, is a great reminder of why it's so important to have these legal documents. You know, Virginia, we always talk about it's not the if, but when you're going to have to go to the hospital with your loved one. And for many people, it's not going to be the if we have to move to long-term care, it's going to be when. So it's important to have all those pieces ready to go in advance now so you don't have to worry about them later. We have a question about the Ladybird deed. Are those forms available online?
I honestly don't know. I'm sorry. I think AGE has some resources for legal documents. Probably the area agency does too. So I would refer you to them for those.
Okay, fantastic. Yes, Alice.
And I can expand on that answer. So yes, those forms, as well as any advanced directives forms, they are available online. You can get copies of them through the benefits counseling program at the Area Agency on Aging, or you can contact Texas Legal Services Center to get assistance in obtaining those forms. Now, Texas Legal Services Center will also help you fill out the transfer on death deeds. Now, you do have to qualify for those services based on income, and so they will have you go through a screening process with them. But the benefits counselors at the Area Agency on Aging, we can help facilitate that process for you.
Right. You know, that brings up a question, since I know that state of Texas does have some of the forms that are available, like power of attorney, and those that you can download and fill out yourself.
Right.
Virginia, when is it best to go through an attorney to do those types of forms? And when is it okay for you just to download them off the internet and fill them out yourself?
I would say a couple of situations. It depends on the amount of assets you have, right? If the more assets you have, it's probably more likely you're going to need the assistance of an attorney to help you make sure those assets go to where you want them to do upon your death. And the other thing would be family dynamics, right? Are you foreseeing some kind of a conflict in your family? Then I would probably want to see an attorney about that. Those are the two that come to mind right now.
Okay. And once those forms are filled out, what happens to them? Are they filed with the state? Do they go somewhere official? So for example, if we went to the hospital with mom and I have had the power of attorney done for her, that the hospital would be able to look it up somewhere? Or do I need to have copies of those to take with me and, you know, have them in my emergency binder that I've got by the door with all of mom's medical information and her list of doctors and all that? Do I need to have copies of those with me as well?
Yes, so I would say if you do a deed, you're going to record it with the county, right? If you, otherwise, you can record your power of attorney document statutory for financial. Typically people don't. But yes, you would have those in a binder. I would make sure everybody who's designated as an agent in there has a copy. If you have a statutory durable power of attorney, I would take it to all the banks or financial institutions so they have a copy of it. But yeah, these are things that you would take with you to the hospital. Your medical power of attorney, your advance directive, your HIPAA release would go with you to the hospital, and you would give a copy to the nurse or whoever's in charge there.
Terrific. We talked about a lot of these things about having your binder, creating your binder so that you've got your information as a caregiver and you have it at your fingertips in case of emergency. We talked about that yesterday in our presentations about caregiving during COVID. Those videos are now online on YouTube, and you can go to the Age of Central Texas website, click on the Striking a Balance web page, and we have them listed there, or just go to YouTube and search either Striking a Balance or Age of Central Texas, and those will pop up. We're going to be adding the videos, including this one today, and the ones for the rest of the week as we go, along with the PowerPoint so that you can review back to those. We're gonna send those out to you as well. Plus, Virginia has a great one-sheet handout that she's provided for us that we're gonna send to you as well that lists all of those documents that she discussed that are important for you as a caregiver to have. We're going to send those out to you probably later today, so keep your eyes open for those. We've got one more question that has popped in. Is there ever a reason for designating the estate as beneficiary for retirement accounts as opposed to a certain person?
Well, if you designate the estate, then that means you're going to be opening a probate. So I haven't ever done that, but I guess you could. It would just mean that the funds would be held there until the estate was opened up, and then they would be transferred there. You can do a revocable living trust. I don't recommend this for a lot of clients, but there are some clients that I do it. And so all of your assets are held in this trust, and you would designate the trust as the beneficiary on an investment account. And then everything, upon the death of that person, everything gets distributed through this trust rather than going to probate. That's another probate avoidance device, but I don't recommend that unless somebody has, a certain dollar amount of assets.
So living trust would be something that you want to use if you've got a lot of assets that you want to protect, or in the event that you've got family issues, you want to make sure things are spelled out well in advance.
Right, or if you have real property out of state, sometimes that's good, because if there's a probate, lots of times you have to go to the other state and hire another lawyer in that state. So it's good that if there's reasons to do a revocable living trust, but again, it's not for everybody because it can be a bit expensive, but it is something you can use. And I have lots of people will do their investments accounts, will list the revocable living trust as the beneficiary, and they go to that and get distributed.
Great. And as always, it's always recommended that you talk to an attorney about all of these things, because every single person's situation is different. And really, you don't want to mess things up, because I know personally from my grandfather, who did not leave a will, trying to go through probate in Texas is the biggest nightmare you will ever experience in your lifetime. Do everything you can in advance to avoid having to do it. Virginia, thank you so very much for all of your expertise. We appreciate that you have done this for us for a number of years. You are such a treasure for us as caregivers, and we thank you so much for spending your morning with us and sharing your expertise. Again, we are going to send you all of these great resources that we have promised to you. They're going to be available online for you as well. And as always, Area Agency on Aging and Age of Central Texas are here for you as the caregiver. That's why our organizations exist. We have folks that are willing and dying to help you constantly, no matter where you are in your journey, because your journey is going to change as a caregiver. And so wherever you are, we're going to meet you where you are on your journey and help you out, whether it's information on legal and financial services and direct you to great people like Virginia, or help point you toward what's available online or the other resources in the community. So please lean on us and let us help you. Again, thank you, Virginia. Thank you, John. Thank you, Yvette. Thank you, Alice. We appreciate it. And thank you personally for joining us today. We hope that you have a great rest of the day. And if you're joining us later this afternoon for our rest of the week for the service, our presentations, we will see you then. Thank you again, and have a great rest of your day.